All right, we are back with Doug Rohan of Rohan Law talking about Florida State's day in court. The ACC, where Florida State is dealt, I wouldn't necessarily say a blow, but a hurdle is the way that it's described here. So let's talk about that a little bit. Doug, how are you doing today?
I'm doing great. Just landed from Denver, had the whole flight with strong Wi-Fi, so got to watch the hearing and tweet out some thoughts as things were going, and then had enough time to get back to the office so that we could hop on here and chat for just a few minutes.
We appreciate you doing this. I said at the end of the last video, but I'll give it a plug at the beginning of this one. If you appreciate Doug doing these and you want to buy him a beer in Ireland, you can do so by going to either our PayPal or Venmo. It's just Double Fries Pod. The link is in the description, and just notate it like Doug or Ireland or beer or whatever. You can buy Doug a beer. You can also do it through the YouTube app. They just take a really large percentage. So if you want more of your money to go to Doug's Libations, then you'll use the PayPal or the Venmo, who take a much smaller percentage. So let's get started on it, though, Doug. Hopefully a lot of people will go buy you beers today after watching this or while watching this. First thing up, though, jurisdiction. Let's talk a little bit about what happened there.
Well, you mentioned that this was a hurdle that was, the judge mentioned and talked about a race with hurdles being run. It's a minor setback. It is still a setback, and this is a delay, especially when we've talked before about the fact that this is going to turn into a race for the two jurisdictions to wrap up their cases if it goes that far. But today's hearing was on the ACC's motion to dismiss, and I mentioned as we were going through the process and listening to the arguments, once we got to this period of discussion right before lunch about the strong long arm statute and the jurisdictional allegations in the complaint, that there was a problem. And I mentioned right away that this was the weakest part of the Florida State complaint and the amended complaint. And essentially what is happening is that there are ways that you can have a person outside of the state sued in Florida, in this case, North Carolina and the ACC being sued in Florida. But as we've talked in several of these videos, the judge has to take the allegations as they are pled. We haven't had discovery. We haven't had any evidence. So it's just what's pled. Well, just like when the ACC messed up and claimed that there was a fiduciary duty on the part of FSU to the conference, the judge decided in North Carolina, Judge Bledsoe decided that there weren't enough facts in that to substantiate the allegation, so he dismissed with prejudice that part of the complaint in North Carolina. Here, what we're talking about is not a specific allegation of a complaint, but how we get to the point that Florida is the proper jurisdiction. And what he said basically was, first, I'm going to give you the lunch break to kind of look at this document again and tell me what I'm missing. And then when we came back from lunch, the FSU attorneys got up and kind of tried to make their best argument that they could, but it's based on the documents that are in front of the judge right now. And truthfully, they kind of whiffed on this part of their complaint. And so the judge told them, I can't accept this as you have alleged it right now. What I will do is instruct you to go ahead and refile, amend your complaint again, establish how we get through all the prerequisites of the long arm statute in Florida to sue the ACC from North Carolina and Florida, and then I'll go ahead and reevaluate this issue. So even the issue of jurisdiction is still not settled. We're basically starting over from scratch again.
Does this surprise you much?
It doesn't. We talked probably, I think, in our second or third video that we did in these series, that I saw right away that this was one of the biggest problems in the complaint. Again, when the ACC filed their motion to dismiss, and they included all of their language in there as to why it should be dismissed, and this was one of the things they pointed to that we really couldn't refute. A lot of their allegations in the motion to dismiss were simply semantics or something that we could point to another document to say that, that's just factually not accurate. But we discussed that this long arm statute lays out the prerequisites, and there was a little bit of thinness in the amended complaint from Florida State. So we identified this early on as being a problem. Again, just like the judges actually evaluating these issues, I didn't know where we were going to go, but it was pretty clear by about 11:30 today, whatever time you were on. I was coming back from Mountain Time, but it was pretty clear right before the lunch break that Judge Cooper had a problem with the allegations in the amended complaint, and that absent being shown something that he missed, that this was where we were going to end up today.
Are you, without knowing their exact strategy or which direction they'll go, what's your confidence level that they can pull something together to impress their standing or improve their standing and impress Judge Bledsoe?
I feel very strong. Again, I will admit I have not done a deep dive into this issue. I'm not the one writing the brief. So at the end of the day, the statute lays out what the secret sauce is for suing North Carolina and Florida, or suing the ACC in Florida, and it's simply going to be a matter of them putting together sufficient facts in an organized paragraph to substantiate and meet those standards. And again, Judge Cooper likely will allow them to connect the dots. I think it's easier to connect the dots. There's a lot of strong arguments in their favor. And perhaps, after we have a little bit more time to get through this, maybe before the amendment is filed, we can talk about what specifically is in the long arm statute and how that should be pled. But, they started off perhaps, and Judge Cooper mentioned this, they started off perhaps thinking this was going to be a federal case. And so some of the allegations that they had in the complaint seemed like they were trending more towards establishing federal diversity of jurisdiction. And then at some point, probably strategically, they just made the decision to change it to state court, but they maybe didn't go back and beef up their allegation the way they should have. So it is a little bit embarrassing. It is a little bit of a black eye for the team. You never want a judge to say that you didn't do your homework correctly, but that's effectively what the judge is saying here is you guys didn't do what you needed to do, but fortunately, it's not something that's going to have a long-term impact on this case. And they will give FSU the chance to take a second bite at the apple, as we like to say in law school.
Yeah. Let's move on to the exit fee and the penalty percentage, not necessarily amount. Let's talk a little bit about where we are with that.
Yeah, so that was one of the arguments that they talked about earlier when the judge, again, he knows this case, he's read all the briefs, and he really wanted to start getting to some of the meat. And I think that was why he was pushing some of these details, because at the end, as you saw, he mentioned mediation, and we'll get into that in a little bit. But he wanted to start picking at some of these scabs that do exist in this claim to try and get the ACC to perhaps realize, look, you're going to win today on this issue, but I want you to start thinking about how I might view these details as the evidence actually comes to light. So one of the things that Florida State argued, and I think Judge Cooper was picking up on, was when the contract was signed in 2016, it was based on a multiplier of the operating budget for the ACC. I drew that distinction in the tweet today because the ACC attorneys were trying to argue, look, FSU knew what this exit fee was and they signed on to it. The attorney corrected herself and did amend her statement. Florida State did not agree with this new change to the buyout clause. They objected to it, but they and Maryland were the only ones that objected to it, so they were overruled. They did sign the agreement, but at that time, it was really closer to about $50 or $70 million because 3.5 times the operating budget at that time, it was a $12 or $15 million budget. That has since ballooned. So while, yes, FSU did sign on to the multiplier of 3.5%, FSU hasn't really been in control of the budget, hasn't really had any controls of what the budget does. And the ACC could manipulate its budget, especially as they're looking to see some of these troubled waters coming, to artificially increase what their operating budget is on their P&L statement or on their profit loss statement, and thereby expanding or increasing what this penalty is. So that might be an issue for a forensic accountant to look at, is how much of their operating expenses are legitimate? Is there some fluff in there? Have they artificially, unilaterally increased that just so that they can make the buyout of the exit fee that much higher?
All right, I want to talk to you a little bit about mediation and the judge kind of pushing toward that. I want to get your thoughts on that. But just before we do that, can you tell me a little bit about Rohan Law? We very much appreciate you doing this and want to give you a sec to chat about that.
Sure. I think I'm pretty sure every show you have new listeners as you're continuing to expand and grow with your subscriber base. So for those that didn't see our previous shows, my name is Doug Rohan of Rohan Law in Atlanta, Georgia. We want to be your best friends on your worst day. If you know somebody in Georgia, I hope you don't need me, but if you know somebody that's been arrested or hurt in a work accident, we'd love to come alongside you and help protect your rights, help you recover the benefits that you're entitled to, and make sure that your financial future isn't impacted negatively. Atlanta Seminole Club is one of the biggest Seminole clubs outside of Atlanta, so I know we have lots of viewers here in Georgia, but all I want you to do is follow us on Twitter, keep following us on X, and then that way, if and when you might need my services in the future, you can consider reaching out to us and letting us come alongside you.
I've had several people tell me I hope I never need Doug, but just based on his going on your show alone, if I ever do, I'm going to reach out. So, yeah, I'll echo that. But yeah, follow along on Twitter, X, whatever. Link that in the description. Doug does a great job of kind of breaking down some of this stuff in real time. I don't want you guys to stop coming and watching these recaps, but if you want to know what's going on in real time, you can certainly find that out on X, Twitter, whatever.
What I will say about that is that, the tweets are limited in characters largely, and there's only so much that you can get out in one particular thought. So these shows are always going to be filled with additional detail and some additional thoughts, things that, we can't put out contemporaneously necessarily right there.
Yeah. So don't skip on these, but if you need some a la carte or in addition to, you certainly can go check Doug out over there. All right. Conversation about mediation. Let's talk a little bit about that. Do you think that's something that's realistic that may happen with this? Is it too contentious? The judge has pushed it a few times now.
Well, the judge is actually saying today he's ordering it. And earlier in the video, if you happen to watch the live stream, one of the FSU attorneys was talking about not wanting to break glass today, and the judge was like, "We'll have plenty of time to do that in 90 days." What he was referring to was that his plan to order mediation. Of course, mediation, two things: it's not 90 days now because we're dismissing this complaint and refiling. He's extended it to 120 days. We'll talk more about what the calendar looks like going forward. But the other thing was the judge did a really good job, Judge Cooper, of mentioning for the live streams and for the people that were watching that mediation is different from arbitration. Mediation is just requires the parties to sit down with a mediator. That mediator has the opportunity to try to work with both parties towards reaching a voluntary solution. It's not something that the mediator decides who's going to pay what or how much is appropriate. And the other thing that the judge mentioned that I thought was a good point is whatever is acceptable. Nobody wins in a mediation. People give up more than they want to give up. People accept less than they want to accept. So in both cases, he's just talking about what's acceptable. The problem is the numbers here are so much larger than a traditional civil case. So yeah, when you're talking about maybe an estate that you're fighting over and there's $200,000 in assets and you're really going to both spend $100,000 in attorney's fees fighting over that $200,000 in assets, and then there's nothing left to be shared between the parties. Here we're talking about hundreds of millions of dollars. So a couple $100,000 in attorney's fees really isn't going to move the needle. So I don't think that argument was the strongest. I think time is what is more important to both parties. They're going to want some assurances and some guarantees as to how these conference realignment situations are going to play out. And I think that's going to be a bigger factor in how quickly this gets resolved, more so than how much they're spending in attorney's fees.
Yeah, a couple $100,000 when the parties are arguing over hundreds of millions seems like absolutely nothing.
Exactly.
20 days to respond now to this amended complaint is what the ACC asked for. Is that correct?
Right. So the judge asked FSU how much time they needed to amend their complaint. It is a pretty simple procedural update. It was interesting. This was one tidbit that I didn't tweet out about, but did become evident. Initially, they asked FSU if they had any intention of amending any other aspects of their complaint, and they said no, they were just going to focus on the jurisdictional issue. Well, then they got into questions about staying discovery and whether or not discovery was going to proceed. And initially, Florida State, again, wants this discovery process to start as quickly as possible. The ACC balked at that. The ACC said no, this shouldn't happen because we have this jurisdiction issue that's foundational. And the judge, in talking out loud and being a verbal processor, ultimately agreed with the ACC that he really can't have any discovery while this issue is pending because we need to resolve this first. The FSU response then was, well, in that case, then we want the opportunity to reevaluate all of our complaint, and we may amend every aspect or various aspects of our complaint. The trick here is I think that's where they're going to go back and amend their complaint to include some of this argument and language that's in the Clemson complaint. So you might see some pretty significant material changes that also take place within this complaint, in addition to shoring up this argument about jurisdiction. But FSU has 7 days, not including weekends. So they're going to have 7 business days to file their response or their amended complaint. And then from that date, whenever that is, the ACC has 20 days to file their full response.
So we're probably looking at a little over a month, maybe even a month and a half. before we have an update. And then I assume from whenever I would assume the ACC takes their full 20 days or pretty close to it. And then we'll kind of hear from the judge on a timeline of a next hearing.
Right. And then 120 days for mediation. We're looking at August for that mediation date.
Will anything else happen with court hearings until mediation is over, or will it kind of pause?
Yes, they will still have another hearing on these issues again, just like we had on April 9th. They're going to have another hearing on the issue of the jurisdiction, really more like today's hearing. They'll come back and revisit the jurisdiction issue. If Florida State can overcome the jurisdiction issue, then the ACC has a few more arguments, not nearly as strong, but a few more arguments to address, which the judge may or may not put any credit into. So what's likely to happen is that if we have a 20-day deadline after a 7-day deadline, that puts us towards the end of May. We'd probably have a mid-June or mid-July hearing. He talked about his hearing calendar already being scheduled out to August or September, but I have a feeling that he would find room in his calendar to try to get this new hearing in before the upcoming mediation date. So that I would anticipate maybe June, July, August at the latest, but he'll want to have this follow-up hearing before they go to mediation.
Any speculation as to why the North Carolina judge didn't talk about mediation a lot? Just personal preference, maybe, or maybe just doesn't think it. Kind of like you said, mediation in a case like this, like how much does it really avail?
Well, in Florida, it's mandatory. So that's why they talk about it so openly in Florida. It's going to be required of all civil cases. They simply just don't have the same requirement in North Carolina. I'm sure that he's suggesting it and will continue to suggest it. We'll probably mention it again on May 2nd when we have that North Carolina follow-up hearing. But it doesn't matter where this is mediated, whether it's in Florida or North Carolina. That's something that they could do in South Carolina if they want. What matters is, can the two parties resolve the ultimate issues of what the grant of rights say and what the exit fee is going to be.
Yeah. Anything else high level or anything else that we missed on today that you want to chat through before we wrap this one up?
Don't accept the bait when the trolls come at you saying that Florida State lost or that this was a huge deal. This is again just like our last hearing, 1.2, 1.3 on the Richter scale. This is very normal in civil litigation. There is one thing to be clear about. It would be unusual for a second opportunity to dismiss and refile. So whatever Florida State files next is going to be, unless a Florida attorney tells me that there's something vastly different than in Georgia, there is not going to be a third chance to dismiss or a second chance to dismiss and refile. So they need to get it right. They've been given their instructions on what the judge is looking for, and I have every confidence that they will be able to do that.
I'll ask you this too. I know you saw this because I saw you respond to it, and I don't know if you have any high-arcing thoughts on it or not, but maybe some language in the Texas, Oklahoma case that ended up happening with ESPN and stuff. I don't want to go too far down the rabbit hole and get anything wrong, but I know that you saw the Flugar episode. Yep. You want to give us some high-level thoughts on that little nugget for those that stuck around toward the end?
Sure. So there was an opportunity that someone was able to secure a copy of the Texas agreement with ESPN or with the SEC regarding their entrance into the SEC and what those agreements looked like. And there was some language in there suggesting that ESPN had an expectation that the conference and the school would participate and work together. And for so long as the member institution was a member of that conference, that the ESPN contract would be valid as outlined in whatever media agreement that they had. The difference that I see, and I don't know this for sure, I'd love to see some additional information, but one allegation that I saw was that that's fine, but there is no standard grant of rights in the SEC like there is in the ACC. I don't know that that's true because all of these conferences kind of operate on the same system. I do know that it's not a 20-year grant of rights. I know that they're not trying to twist the arm of the SEC members to stay in the SEC because who other than Texas A&M would want to leave the conference? But the question is, and the issue is the language in the FSU ESPN agreement with the ACC the same as the UT University of Texas agreement with the SEC. If that language mirrors itself, which we've seen, they copy these documents over and over and just change the parties' names, then I think there is a very strong argument in those ESPN agreements with the ACC that the point that Clemson has made and that FSU is making is valid. If there is no membership in the conference, then the ESPN agreement ceases to exist. And as we pointed out before, if the ESPN agreement ceases to exist, then the grant of rights ceases to exist. So it's a little bit of a circuitous route to get there, but that's why we need to be able to see what's in the ESPN agreement with the ACC. Because if that language is the same, then perhaps Clemson has hit the nail on the head and every party can leave the conference unilaterally without any penalty.
It would just be your exit fee at that point, which we are fighting again. That percentage, is it really that
Mhm.
120? Where are we at? But 120
Right.
is probably a lot more palatable than 571 or whatever
And
number we're at right now.
that was the point they made today in the hearing. FSU is citing to a case where this exact issue was determined that a $50 million penalty was inappropriate, was against public policy. So the Florida state attorney was saying if $50 million is against public policy, then clearly $140 million also has to be held against public policy. To which the ACC's argument is it's not a penalty, it's just a contractual agreement. And that's where Judge Cooper was hitting him. We have stuff that's in contracts all the time that people sign that is voided because it's against public policy. And the ACC attorney had to agree that that was, in fact, true in Florida.
Fingers crossed that we can do something for that. We'll get Harlan to pony up the 120 if that's all that we have to end up paying. So, Doug, I appreciate you for hanging out. Again, if you want to buy Doug a beer, hit our PayPal, hit the Venmo. You can hit the super thanks if you'd like to hit that as well. But we appreciate you a ton for doing this.
Always.
And I'm sure we'll see you right around the 1st of May when we're back in court again.
It does not appear that this is going to slow down.
Good stuff, man. Thanks for your time, and go Noles.
Go Noles.